How do you prove employer unfair labor practices to the NLRB? Imagine you're at work and feel your rights to support a union are being blocked or threatened. How can you show this is happening? That's what we're here to find out. When employees or unions suspect an employer is interfering with union activities, they need solid proof to bring their case to the National Labor Relations Board. First, anyone can file a charge with the NLRB. This includes employees, union representatives, or even third parties. You do this by submitting a form online or in person at the regional office. The charge should clearly state what unfair labor practice you believe the employer committed, like threatening employees or refusing to bargain. Once the charge is filed, the NLRB begins an investigation. NLRB agents gather evidence by talking to witnesses, collecting written statements called affidavits, and reviewing documents from the employer. They look for proof that the employer did something illegal under the National Labor Relations Act. To prove unfair labor practices, you need to show that the employer engaged in specific prohibited actions. These include threatening employees with job loss or punishment if they support the union, questioning employees about their union activities in a coercive way, disciplining or firing workers because of their union involvement, promising benefits to stop union organizing, refusing to bargain with the union, or withdrawing recognition without good reason. The NLRB uses the Wright Line test to decide if the employer's actions were motivated by anti-union feelings. This means showing that the employer's conduct was at least partly driven by hostility toward union activities. Evidence can be direct, like a boss saying they don't want a union, or circumstantial, like a pattern of threatening behavior. After the investigation, the NLRB sends a letter to the employer asking for an explanation and relevant documents. If the evidence shows the employer broke the law, the NLRB tries to settle the case. If no agreement is reached, the case moves forward to a formal hearing. At the hearing, both sides present their evidence and arguments. An administrative law judge then decides if the employer committed unfair labor practices. If they did, the NLRB can order remedies like reinstating fired workers, paying back wages, or stopping the employer from illegal actions. In union organizing cases, proving unfair labor practices often means showing the employer tried to stop employees from supporting the union through threats, coercion, or false promises. It's important that employer statements about unionization are honest and do not mislead or intimidate workers. To sum up, proving unfair labor practices involves filing a charge, collecting evidence of illegal conduct, and going through an investigation and possible legal process. This process helps protect employees' rights to organize and bargain collectively without fear of employer interference.